objection to these very outrageous holding practice?
Essentially, what your Honor, senior counsel is the court is to defer the hearing of this application. We want to reiterate that we are appearing for freedom fighters who are fighting to liberate themselves. So, Your Honor, the application is that we defer the hearing of this application and we grant bail to the suspects. Of course, Your Honor, I refer you to Article 49, Clause 1, Paragraph H, which provides that an arrested person has a right to be released on bond or bail on reasonable condition, pending a charge or a trial. Pending a charge. That is the basis upon which our application is made. This is not the first application of this nature. They have been made previously, and noting that the application that we shall canvass in the future, if the court is obliged to hear us, they are only proposing petty offenses, misdemeanors. When you look at that, my Honor, as against, again, Article 49, Clause 2, it provides that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by an imprisonment for not more than 6 months. So, Your Honor, our application is well seated in within the four corners of the Constitution. You grant us bail pending the hearing of this application. The application has just been served upon us. The application presupposes to investigate petty offenses and will not prejudice the applicants in whichever manner if the application is granted. We most obliged.
Before the Your Honor, if I may, my name is Mano Jose. On behalf of the Law Society of Kenya, I want to bring to your attention the constitutional petition number E714 of 2024, wherein Your Honor, Mr. Okiyah Omtata, who is a respondent in the application so presented in court, is the third interested party. Your Honor, in the said petition, Justice Bahati Momunyi has issued orders that touch the subject matter that is before you, that is the demonstrations and also the abductions. So that, Your Honor, any directions issued before you this morning might be contrary to the Superior Court's directions issued today, this afternoon. As we speak, and I think Senior Counsel Kalonzo Musyoka and Martha Karua were in that court. Your Honor, we supply a copy of the court's directions that were issued yesterday, and we endeavor to supply this court with the directions that were issued this afternoon. So that, Your Honor, any directions that you will give, we seek that they be subject of the directions that have been issued by a Superior Court, perhaps after this 8th, when we appear before that court for further directions. That is our prayer.
Proceedings before justice was moved. And when I would like to submit that those orders do not touch on matters this proceeding in Parliament. The application that is before this court today is merely seeking custodial order against the prior respondents having been arrested yesterday. The said application supported by an affidavit by one Corporal Anthony Kelly, whereby he is seeking.
Your Honor, my apologies to interject. The prosecution seems to be prosecuting the application. However, senior counsel had indicated that we need to discuss before we get to the substantive hearing of that application. Because the court will kindly give directions on the request by senior counsel, and then we are able now to take proper directions in whether the DPP prosecute that application or not.
Unfortunately, I'm cautious. I was making a basis of what is before this court. Your Honor, the application before you is seeking custodial orders for 14 days. Your Honor, if we go by what the senior counsel was saying, that we directly dwell on the issue of bail, we will have already canvassed this application here. It will have been spent because the application before you is seeking for custodial orders against the 23 respondents, so that the IO can achieve 1, 2, 3 issues that will enable him to charge the same person. If we go directly and say that today they be released on custody, it will already be, the application will be an academic exercise. So before
any description, they didn't carry any stones. If anything, I think they chained each other, making it even more difficult for them to move. Peaceful Kenyan demonstrators. And therefore, Your Honor, for anybody to say an affidavit wanting to hold them for 14 days is going against the spirit, the letter and the spirit of Constitution 2010. They are not, we do not know, nobody actually say, because the only reason you can hold Kenyans is if they are for the kind of period the prosecutor is talking about, is if they are suspected to be terrorists, in which case they would have been arraigned before a court, I think a terrorist court something in Kiambu. And therefore, Your Honor, we strongly urge that this court protects the right to peaceful demonstration, we believe there's absolutely no reason to hold Kenyans who have been singing peaceful, patriotic songs. That is not an offense. Your Honor, we urge that you come to the help of your country by dismissing this application with the contempt it deserves, because it is unconstitutional, it's even unethical, and it defeats logic.
Your Honor, we don't have a because there are some issues that are coming up, matters of past and order. I think the court should just give us a direction in regards to whether matter to proceed or the deferment of the
I think, Your Honor, he has already made his application.
Yeah.
Even though I had objected, he has made his application. We are now responding. So he must hold his peace.
Yeah. No,
We respond, because what else would you have to say other than what is in the affidavit? You've already objected to any application. So let us respond to you. We have something to say. I want to be last to let my colleagues go now.
Your Honor, I was not done. I was cut short by my colleagues. And it can go on record.
My lady, I had the pleasure of appearing in the matter 249/2024. This is the state regarding Boniface Mangi, and I appeared alongside Senior Counsel Martha Kagua. The charges which are being referred in the application, there is a recommendation, a letter which was issued by the ODTP in regards to the copy-paste. This is creating disturbance, which has actually been listed there, and local assembly, which has been stated there, and also section 79. And the upshot of this particular letter, which was signed off by the acting director, that was Dorcas Ragat. Consequently, the DPP directs that the evidence presented has not met the evidentiary threshold to warrant approval for the proposed charges. Therefore, the application to actually be, the persons be actually granted bail is actually rightly before this court. The prosecutor meeting, rather trying to prosecute the application in itself, it does not stand in itself.
Your Honor, with your kind permission, my name is Daniel Manzo, representing the team which has been presented before you. Your Honor, Article 49 and 50 are clear as to the rights of an accused person. And one of the rights is right to bail, which would have been issued at the police station, which can be issued by this court. And further to that, all constitutional issues, Your Honor, are already raised in the petition presented before you, and therefore, nothing forbids you from going on to exercise the Constitution and release accused persons on bail pending the hearing of this particular application, which, Your Honor, we submit will be lengthy. We present all the laws dealing with this, and belonging to the senior bar, Your Honor, I'll tell you this happened years before, before 2000, and the responses and the precedence is very clear what happens in this particular sort of thing. In fact, it has not happened, Your Honor, for the last 25 years. And therefore, we want to canvass it conclusively under the new constitution so that all Kenyans, Your Honor, are happy with it, and that the court cannot be rushed into just agreeing with the police officer who sworn an affidavit here, which in the first place is defective, and secondly, discloses no offenses. For there to be a charge sheet, Your Honor, there must be there must be an offense which is disclosed on the face of the document. I thank you, Your Honor, and agree with my seniors that the accused person be first and foremost be released on bail.
Now giving you my directions on whether we are going to proceed.
Address the court on the issue of the application amounting to an application really for pre-trial detention. Your Honor, I have had the affidavit read to me. It does not disclose what security risk they are not even accused.
are going to subject if they are released before that 14 days. They have not really indicated what nature of investigation are pending and which they couldn't have investigated by yesterday. They have not indicated at all with what charges they